The tenancy agreement itself will be in the form as it is now as a schedule to the regulations. That's currently being prepared right now, and the same will be for the condition report. So that, obviously once we see the compulsory section, we'll be doing as we've done previously, designing special clauses which will help reinforce the rights of the landlord particularly, and running in parallel with the compulsory sections which will be in the schedules themselves. So that will be, once we've got the regulations underway, that will be a #1 priority from the Institute's point of view, is to make sure that the document is made available, ready to be issued from the date of commencement of the actual legislation, which again we still don't have a start date. Those of you who read that draft bill, there are a lot of provisions for penalties, and particularly the things that concerned us were penalties against real estate agents for breaches under tenancy law. We've got enough of them under the property stock, but to have them also lobbing up in the tenancy legislation, now they're virtually gone. The landlord can receive some penalties, but the penalties as far as the real estate agent is concerned have virtually disappeared. Now, there was a provision under the proposed section to do with documents being in writing, to have a penalty which is payable by the landlord of 20 penalty points for failure to produce a written document. That's $2,200 if you can't convert right. So for each breach, the landlord could have been up for $2,200. That's been knocked out altogether. But there is a bit of a penalty still there, and that is that if you don't have written agreements, then there is a provision under section 14.3 of the new bill that the rent cannot be increased in the first 6 months of that non-documented tenancy. So you can't increase the rent in 6 months, and you're not entitled to terminate under a no-blame notice of 90 days during the first 6 months. So you can see that puts a brake on any action you can take. From an agent's point of view, I can't imagine an agent entering into a tenancy arrangement without anything in writing. But this, bearing in mind, this covers private landlords as well, and some people have reasons for not having written agreements. So from the professional point of view, I would think we would always be looking for a fixed term agreement to start with, so that you can put in place all of the other things that flow on once the agreement finishes. Next one that you've lost is your preparation fee from the tenant. It's gone. Doesn't mean you can't charge, but you're going to be in a situation of negotiating any fees for preparation with your landlord client. Under this new section, 23.1, all you can take is a holding fee, the rent, the bond, and the registration fee if it's a long-term lease for registering the agreement against the title of the property. So if you've got those, you can actually collect that from the tenant. Section 23.2 says, and this makes it fairly clear, a person must not require or receive from a tenant an amount for the cost of preparation of a written residential tenancies agreement. So there you go. What we've had as part of our income for all of these years is now gone. So maybe you've got to put your negotiation hat on and go and talk to all your landlords and say, guess what, it's going to cost you a little bit more. Or you absorb it. The problem with real estate agency is that you get agreements in place and you're happy and comfortable with them, and you don't want to run the risk of losing it, so they don't want to go and renegotiate. Some agencies are actually doing it and getting away with it because the costs involved in compliance these days are much greater than they used to be, and the amount of work that goes into a lot of the management side of your practice needs to be paid for. I mean, we give away far too much. So maybe that's just a time with the introduction of new law, you talk to yourselves and your clients about the actual costs. I mean, it shouldn't be a sin for any real estate agent to make a profit. But sometimes when you talk to some of your clients, you'd wonder whether they really think that you're entitled to a profit. Now, what's in it for me? You know, if I do this, how much are you going to reduce my fees? Or the bloke down the road will do my management for 2%? Yeah, right? So all that sort of stuff. And the truth is that a lot of real estate agents are very, very poor negotiators. They like to be peaceful and happy and keep their clients happy, so that's where it all stops. The next one, I think probably we'll talk about is prohibited terms. Very similar, well, similar in some respects to the other agreement. You can't have any additional clause in the agreement which is in any way in conflict with the law. But they've been a little bit more specific, and I'll just pull up the actual legislation. We can talk about that for a second. Under prohibited terms, a residential tenancy agreement must not contain a term which is in any way conflict with the legislation. Specific terms which are taken out. Number one is the high on the list, and it's been a hit list for the CTTT. The tenant must have the carpet professionally cleaned and pay the cost of such cleaning at the end of the tenancy. That is a no. Gone. All right? So what you've been able to sneak away with for years is now actually included in the actual legislation, and so if you've got it in your agreements as of the commencement date of this, it is illegal.
Can you still charge them if there's damage?
Oh yes, cleaning is a different issue. Right. Cleaning is different. And we get to the end of this, and I'll tell you about a clause that I wrote, which is now in the legislation, which I'm terribly excited about.
What about excellent?
Don't you pinch my thunder. You can't require the tenant to take any specified or any form of insurance. Now, I think that's grossly unfair. I think that there should be a situation where the landlord should not have to be the insurer of the tenant. And in lots of cases, the tenants go to the tribunal claiming damages which they should have insured themselves. And the landlord finishes up paying for them because they find that the landlord in some way has not presented the property correctly, and as a result of that you've got a landlord who's virtually paying an insurance claim of the tenant. And how many of you had that experience over the years? That you go along there and they say, oh, but this, that, the mould got my this coat or whatever, my shoes, and they claim the damage, and the old landlord has to pay for it. So making people liable, or landlords liable, the fact that things like a 100-year flood, right? You're having to disclose at the point of the leasing of the property things that may cause a problem. If you're in a bushfire-prone area, it would be something you might have to declare to the tenants. It may well involve, and if it's not substantially reduced, you'll be in a situation where you have to do searches of title, getting zoning certificates to see whether or not there is anything that might affect that property. And overall, that comes down to a landlord providing some guarantees to the tenant. Don't know?
It hangs, for me, it hangs well together with insurance. So yeah. Some of the, we haven't yet seen this, I guess it's the regulation's still in draft, but they gave us an indication they were looking at those sorts of floods, fires, these sorts of things. Now having, I guess, the tenant insured means that there is something there to respond in those circumstances, but we're not permitted to insist on insurance. And yet, if there is anything that goes wrong, and Tim points out the 100-year flood, potentially at least we could be, as landlords and as agents, responsible for any damage. So I'd have difficulty reconciling that, but that's a problem we need to grapple with and work through. You
can stretch that a little bit further. There's geological evidence that said there's a tsunami hit the Sydney area about 500 years ago, and the wave was 300 feet high and travelled all the way to Parramatta. Perhaps we should put that in as well.